But there's a few basic things I'll start with at the beginning. They may seem kind of simple, they may seem kind of silly, but I promise I'll try to tie it all in toward the end of the presentation. First off, what is a warranty? And I've got two dictionary definitions from dictionary.com. A stipulation, explicit or implied, in assurance of some particular in connection with a contract as of sale, or a written guarantee given to the purchaser of a new appliance, automobile, or other item by the manufacturer or dealer, usually specifying that the manufacturer will make any repairs or replace defective parts free of charge for a stated period of time. Now, two dictionary.com definitions are somewhat important to understanding what a warranty is, because when the FTC looks at warranty issues, they try to use what they consider to be just a reasonable consumer standard. So if you're discussing a warranty with a customer, that customer's understanding of what a warranty is going to be probably similar to what dictionary.com would say, or at least the FTC would assume that that's correct. Now, within the Magnuson Moss Warranty Act, there's also a set of definitions. And the Magnuson Moss Warranty Act is going to be a heavy portion of my discussion today, because it's a federal statute that governs what you can and can't do in a warranty, how they're applied, and it creates certain rights to your customers if you're giving any type of a warranty. Now, what Magnuson Moss says is a written warranty is a written affirmation of fact or written promise made in connection with the sale of a consumer product by a supplier to a buyer, which relates to the nature of the material or workmanship and affirms or promises that such material or workmanship is defect-free or will meet a specified level of performance over a specified period of time. And then there's an alternate definition, but I just want to talk about this one for a second, because the way that this definition is written is that any written affirmation of fact or written promise made in connection with the sale of a consumer product can be a written warranty under Magnuson Moss. You don't necessarily have to have all the formalities of a written warranty. There have been instances where courts have said a pre-delivery checklist that has been given to a consumer by an auto dealer, one of those deals where they said we got a 64-point inspection. The vehicle undergoes a 64-point inspection before it's sold. The copy of that 64-point inspection is given to the customer. Courts have interpreted that 64-point inspection to be a written warranty under Magnuson Moss for purposes of those 64 points. That you're giving the customer certain assurances regarding those points of the vehicle, and the impact of giving a customer a written warranty that's big for mostly everybody is you can't disclaim implied warranties. And there's a big portion of the presentation that we'll talk about that. But so indirectly, by telling somebody we got a 64-point inspection and giving them the list, you could be creating implied warranty issues. Now, you can show, well, if it's in writing, it can be deemed a warranty, whether they have a copy of it or not. Again, I think computer would be a writing. Now, a lot of people advertise, you know, our vehicles undergo a certain number of inspections and things like that, and I have a section on advertising your warranties, but there's no clear answer to that question. And a lot of the warranty actual creation and what's governing the content of warranties other than Magnuson Moss is state law. So you're going to have different decisions all over the country, and I've got some examples of strange situations that turned into warranties or things you might think would trigger a warranty that didn't, simply because that's the way their state interpreted the law. It could. Yes, the condition report, you could be stating in the condition report certain affirmative promises regarding the material or workmanship of the vehicle. So it could fit into that. Now, the secondary portion here is, the secondary definition is any undertaking in writing in connection with the sale by a supplier of a consumer product to refund, repair, replace, or take other remedial action with respect to such product in the event that such product fails to meet the specifications. And that's the more traditional idea of what a warranty is. But based on the definition within Magnuson Moss, there's the or. So it could be either. And then the written affirmation, promise, or undertaking has to be a part of the basis of the bargain. So generally speaking, you've got to give that information to the consumer before they agree to purchase the vehicle for it to be a written warranty under this provision. So if after they've already bought the car, you know, a week later you send them the condition report, then it wouldn't be necessarily a written warranty under Magnuson Moss because it wasn't part of the basis of the bargain. They didn't see it before they decided to purchase the vehicle. Now, service contracts are slightly different. Under Magnuson Moss, the term service contract means a contract in writing to perform over a fixed period of time or for a specified duration services relating to the maintenance or repair or both of a consumer product. Now, service contracts are usually written warranties, but they're not part of the basis of the bargain. There's a separate charge for them. And you know, a lot of people use the misnomer extended warranty. There's no such thing theoretically under Magnuson Moss. It's either a written warranty or it's a service contract. If the customer's got to pay separate money for it, it's a service contract. Now, the other key terms that are important to understanding exactly the way Magnuson Moss works is warrantor. And again, the definition is important because it doesn't limit the warrantor to being the person who is responsible for the repairs under the warranty. The supplier can be a warrantor under certain circumstances. So the dealer that's selling the vehicle along with a warranty, whether it's a third-party warranty or your own, and I have clients that do it both ways. Some of them buy a separate standalone 30-day warranty. Others, you know, say bring it back to me within 30 days, 1,000 miles, I'll make it right if there's something wrong with it. In both of those situations, that dealer can be a warrantor, even in the situation where they've got the third party responsible for the repair work. Under certain circumstances, they can adopt the content of that warranty, and I'll talk about a case where that happened with a franchise dealer. So simply because somebody else is responsible for the repairs, that doesn't necessarily mean you're not a warrantor. Supplier, that's essentially the person who's selling the product or who's selling it wholesale to you. You know, whether it's a franchise dealer or another dealer, they can all be deemed suppliers under Magnuson Moss. And then implied warranties, everybody probably has some familiarity with them, but for purposes of Magnuson Moss, it says it's an implied warranty that has to arise under state law. And every state's going to have different implied warranties. The big one is usually the implied warranty of merchantability. That's the one where most lawsuits will happen. That's the one I deal with a lot in Florida. And essentially what the implied warranty of merchantability means is that the good that you're selling would pass in trade, and it would be of similar condition to a vehicle of the same year, age, and mileage. It doesn't mean it's perfect. It doesn't mean that it doesn't have defects. It's sort of an average vehicle within the trade of vehicles. It would be the same as any other, you know, 1982 Pinto or whatever it is you're selling. It would have the same problems, the same defects. It's not perfect, but it would be similar to those types of vehicles. Now, where do dealers fit in all this? Well, you're almost always a supplier because you're the one who's selling the vehicle. In certain circumstances, you can be a warrantor, and that's where the concern arises, both in the supplier side and the warrantor side, because you can be responsible for paying for repairs if you fall on the warrantor side. Onto the supplier side, you may have an obligation to honor implied warranties if they apply in your circumstance. Now, Magnuson Moss is the federal statute. Its purpose was, by Congress, supposedly was to allow consumers to fully understand the contents of warranties and allow them to comparison shop based on their findings. I don't know of anybody that has ever had a customer come in and say, can I see a copy of your warranty? I'm shopping around based on the content of warranties for used vehicles. It just doesn't make any sense. People don't shop that way. But under Magnuson Moss, you're required to have your written warranty available to people if they come by and say, I'd like a copy of it. You're supposed to give it to them. Again, I don't think it applies that way. I don't think it works that way, but that's the express finding. What was the effect, though? There's litigation and confusion about what Magnuson Moss requires and how it applies and what you need to do with warranties. And most importantly, it does not create a requirement that a warranty be given. And I've litigated that issue in Florida on 2 different occasions. Different lawyers think if it's a consumer product, Magnuson Moss applies and requires you to make some kind of a warranty. You can't sell a vehicle as is their theory under Magnuson Moss, and it's just simply not true. If you do offer a warranty, then there's certain conditions that have to apply. But under Magnuson Moss, there is no prohibition on as-is sales. Now, some states may have, and I know California is kicking it around that every dealer is going to have a 30-day warranty on their vehicles, which would be independent from Magnuson Moss. But under this statute, and this statute also has an attorney's fees provision, as do most federal statutes. So if someone brings a claim against you under Magnuson Moss, they're going to be seeking to recover their fees at the end of the day and their costs. It also allows for rescission. So you can have a customer come back 2 years later and try to rescind the deal and say, give me back my money, you get a minor set-off for my use of the vehicle. I want to unwind this deal because now I've found out that there's a condition on this vehicle that wasn't disclosed to me. The Carfax you gave me was inaccurate. That's one of the merchantability issues that's going to be litigated, I think, heavily in the next couple of years because more and more information is becoming readily available. So a Carfax you have today may not be accurate. 2 years later, they go to trade the car in, and now they're told, well, that vehicle had prior accident damage, and they're going to say, well, you're handing me a Carfax is a written affirmation of a fact regarding the vehicle that formed the basis of the bargain. That's a warranty. Now, whether courts are going to interpret giving somebody a Carfax, especially when it says on it that there's no reliable data in it and that it's all subject to mistake and error and everything else, the disclaimer at the bottom's pretty ridiculous. But conceptually, it would meet the definition of a written warranty so as to allow somebody to make that type of a claim. Now, as I mentioned, there are two categories of warranties. There are full warranties and limited warranties. Full warranties have a set of specific statutory criteria that have to be met in order for you to be able to say you are giving a full warranty. Limited warranties are substantially different. They allow you to exclude things. They allow you to place limitations on what's covered. They allow you to put conditions on the consumer in order to make a claim under the warranty, but they just have to be disclosed as being a limited warranty. In either situation, though, Magnuson Moss prevents you from disclaiming implied warranties if you're making either a full or a limited warranty. If you're offering a full warranty under the statute, you may not impose any duties on the consumer other than notice unless the warrantor can demonstrate reasonableness. You must provide that the warrantor will remedy the consumer product within a reasonable time and without charge in the case of a defect, malfunction, or failure to conform with the written warranty. And there are cases out there because remedy in this situation means replace or repair. You can't give the customer their money back unless they agree to take it. Or you've tried to repair it and it's not commercially reasonable. And you run into this in situations where you have specialty vehicles that come with some kind of a warranty. The customer says, I don't want my money back. This is a classic car. I want you to fix it or make it merchantable. So the fact that they have to agree to it or you have to be able to demonstrate that it's commercially unreasonable can be a problem. Virtually no one offers full warranties. I mean, every now and then you'll have some major appliances that have them, but there's just too many restrictions to make them workable. If the warrantor can't remedy a defect or malfunction after a reasonable number of attempts, the consumer then can elect a refund, so it's up to the consumer again. But it does allow warrantors to disclaim damage that doesn't arise due to a defect or malfunction or that was caused by misuse of the product. So you get that perk, I guess, if you're using a full warranty. Much more likely you're going to have a limited warranty of some sort. There's no real federal requirements as to what you can or can't do in a warranty. There's a disclosure process as to what you need to explain to the customer, and that's on the next slide. But other than that, you can create your own warranty. I mean, you can warrant the tires only if you want. Your remedies under state warranties are limited to state law and the warranty's terms, so you create what the remedies are in the case there's a problem. And most warranties that are available, whether it's third-party provided warranties or warranties that dealers are doing, are limited. Now, this is the section regarding the disclosure of contents of written warranties. There's 5 questions that the FTC says you need to answer. 1, what does the warranty cover? Well, that's common sense. I mean, you can make it cover whatever you want. What's the period of coverage? Most people are able to set up a warranty that has those provisions in it. What will be done to correct the problem? Now, this gets tricky because if you limit it to repair or replace, then you may take yourself out of the refund possibility. The FTC has said you may need to include what will not be done in order to make the customer understand the terms of the warranty. Now, that seems to me to be overly burdensome on the people that are putting together these warranties because there's a whole bunch of stuff you won't do. You have to list everything? Right, and they don't give you much guidance. They just say in some instances you may have to be specific. What does the customer need to do to get warranty service? And how will state law affect the customer's rights under the warranty? Well, that last section caused a huge issue, and people that were operating under Magnuson Moss said, well, wait, how am I supposed to advise a customer on state law So the FTC came out and said, if you put this language, you satisfy number 5, and it just says this warranty gives you specific legal rights, and you may also have other rights which vary from state to state. So if you're offering some type of a limited warranty, make sure that that little disclaimer is in the body of it somewhere. This is the FTC example of a limited warranty. And this is one for, I think it was a hearing aid, and they indicated that this was perfectly fine, and it's a model that they propose people use for their own warranties. And they lay it out just like the questions say. What does the warranty cover? This warranty covers any defects or malfunctions in your new Magnifisound hearing aid. How long does the coverage last? The warranty lasts as long as you own your Magnifisound aid. Coverage terminates if you sell or otherwise transfer the aid. So there's a limitation there. What will they do? Well, they'll refund and replace any defective or malfunctioning part at no charge. You must pay labor. You can do that in a limited warranty. You can require the customer to pay the labor, you just provide the parts. What does the warranty not cover? And this one spells it out. That's probably why the FTC picked it. They liked it. It doesn't cover batteries or any problems that are caused by abuse, misuse, or an act of God, such as flood. I don't know why they put flood in there. Some states don't allow the exclusion or limitation of incidental or consequential damages. You have to put that in if you're going to do that. So the above limitation may not apply to you. How do you get service? And they've got a whole process here. In order to be eligible for service, you've got to return a warranty card within 30 days of purchase. If something goes wrong, you need to mail it back with a description of the problem to this address. They'll inspect it and contact you within 72 hours to give you the results and an estimate. It says if you authorize the repairs, they'll return it to you. If you don't authorize the repairs, they'll send you the parts and you can take it somewhere else to get it fixed. And then how does state law apply? There's the nice little disclaimer that the FTC says to put in there. We've been talking about implied warranties. As I mentioned, they're created by state law, so they differ. So if you offer any type of warranty, even this limited warranty, the implied warranties are coming with the car. The benefit to a limited warranty, unless you're in one of those states, Alabama, Connecticut, Kansas, Maine, Maryland, Massachusetts, Minnesota, Mississippi, New Hampshire, Vermont, Washington, West Virginia, and the District of Columbia, you always give an implied warranty. You can't disclaim them. It's just not permitted under state law. So other than those states, you can limit the implied warranties to the term of your limited warranty. So if you've got a 30-day, 1,000-mile warranty, you can limit your implied warranties to that same term if you're doing a limited warranty. Now, if you do, and you'll note here, no supplier may disclaim or modify any implied warranty to a consumer with respect to such consumer product if you make a written warranty or at the time of sale you enter into a service contract within 90 days. But if you're going to offer or limit the warranty, limit the implied warranty to the term of your limited warranty, it has to be set forth in clear and unmistakable language and be prominently displayed on the face of the warranty. So somewhere in there, you've got to put any implied warranties are limited expressly to the term of this warranty, 30 days, 1,000 miles. And usually the way that I satisfy that for clients is I say any implied warranties created by operation of state law are limited in duration to the term of this warranty. You try to make it in big type so that they can see it and make sure that that's in there. Otherwise, the case law says if you don't do that, the implied warranties go on, I guess, in perpetuity. They exist forever. Now, I mentioned that I had a case. This was a client. I didn't create this. He brought it to me and said, I've been sued by this thing called Magnuson Moss. What do I do? Now, he said he never heard of it. He didn't understand what Magnuson Moss was and just sold the car as is. That was his big thing. I sold the car as is, and I give a 30-day warranty. That's it. Well, this was his entire warranty. This looks nothing like what the FTC says you're supposed to use. Now, arguably he's got the what is covered down there at the bottom. It says systems covered, engine and transmission only, does not include the clutch on manual vehicles with a $250 deductible. So, I mean, I guess for purposes of what is covered, that's what's covered. To me, that's pretty broad, but that's what he listed as being covered. The term, he had that, down here, 1,000 miles or 30 days, whichever comes first. He doesn't have what's not covered. He doesn't have the language that's required regarding state law. But most importantly, he has no limitation of the implied warranties. So he said, I want to fight this. I don't think it's a legitimate claim. The judge ruled that he didn't do it conspicuously, so the implied warranties exceeded the 1,000 miles or 30 days. He had another problem here. I asked him where he got this form. He said he pulled it off the internet. It says, ask the dealer for a copy of the warranty document and a full explanation of warranty coverages, exclusions, and the dealer's repair obligations. I said, where's the document? He said, I don't have that document. So well, you've told them that you're going to give them some document that has this stuff in it. And then, we're going to go to court, and you're going to say, well, I don't have that. And the judge is going to say, well, then you're bound with this. I mean, this is your warranty. It's not in compliant with Magnuson Moss, and you didn't properly limit anything. So keep in mind that if this is the type of form that any of you guys, it's just the buyer's guide. I don't know how he thought that was a warranty. We ended up settling the case. He was unhappy. But he told him he didn't have a choice. He was going to end up paying their attorney's fees because the vehicle had some problems and it wasn't merchantable. The question of who the warrantor is somewhat technical because suppliers that don't make their own written warranties or service contracts may be permitted to disclaim implied warranties. The only way you can become a warrantor as a dealer is if you somehow adopt the warranty. We've got this case, this Idaho case that I know here. Dealer's acknowledgement of manufacturer's warranty did not make the dealer a party to the warranty, and thus dealer could disclaim implied warranties. Okay. There's a later case, different state, where a franchise dealer sold a vehicle, and on the dealer's buyer's order it said, the only warranty offered by the dealer is the manufacturer's warranty. Please see a copy. The typical language is in a buyer's order. The court said that the dealer was adopting the manufacturer's warranty because a reasonable consumer reading that statement, the only warranty offered by the dealer is the manufacturer's, would understand that the dealer is offering the manufacturer's warranty. So they said, I think it was an Illinois decision, they said the dealer absolutely adopted the manufacturer's warranty. You're a co-warrantor now with the manufacturer on this vehicle. You've adopted everything that's in their warranty. You've got all their requirements to maintain the vehicle for the next 3 years because it's a brand new car. And it was all because of that one misstatement, I guess, in the dealer's buyer's order. And then they said you can't disclaim implied warranties either because now you've offered a written warranty. I guess the way that the dealer should have limited that would say the only warranty extended to the dealer is not making any warranty relating to the vehicle. The manufacturer's warranty may apply. I don't know how else you could do it in such a way that would not potentially cause you to be adopting the manufacturer's warranty. There's a case, and it comes up a little later, but I might as well speak to it now, where the warranty company required the customer, or the warranty that was offered by the third-party warranty company, required the customer to return to the selling dealer for service. And they said by doing that, the dealer was a co-warrantor because it was obligated under that warranty. So by obligating them to come back, they said, you're now a warrantor. Actually, there is an interesting provision in Magnuson Moss because it says if you require an alternative dispute resolution mechanism, you have to include that in your warranty. And there is a case out there that finds arbitration to be an alternative, a pre-suit alternative dispute resolution mechanism or something. And it's really not. And there's a series of cases, there's 4 or 5 different federal courts that all misinterpreted the statute essentially and said if you have an arbitration agreement, it's got to be in your written warranty. If it's not, it's unenforceable for warranty claims. Florida courts have held that way based on that misperception. Some judges have backed off of it. But just be aware that if you do have an arbitration agreement, you may get some kind of a wacky case that says, for whatever reason, binding arbitration is a pre-dispute settlement mechanism. I mean, what they wanted to do is, a lot of times manufacturers have complex steps you've got to go through before you file a claim. We'll go mediate. We'll have a special master that will look at everything and make a recommendation. It's not binding on anyone. And they didn't want those hurdles to be hidden from consumers when they're going to the dealer and getting their warranty and comparing, the warranties from the various dealers, like the purpose says, they're supposed to be doing. The designation of the supplier as a representative of the warrantor does not make the supplier a warrantor. That's expressly from the statute. So, a franchise operation where they got a service department and that's the manufacturer's agent for purposes of performing service repairs, it was not going to make them a warrantor. That's statutory. In some instances, warranties indicate that the dealer should call a number or present the vehicle to the dealer that sold it to them to make a claim. I think by giving them the option, you've not required the customer to return to the dealer that sold them the car, so I think you fall out of that bad decision. And you would be an agent at that point for the manufacturer, for the warrantor, to determine what was wrong with the vehicle and what needs to be done. This provision, I think, would give you coverage so that you wouldn't have to do that. A service contract that obligates a third party to perform services does not automatically make the dealer a warrantor. Adoption still has to occur. That's the case I was talking about. It's a Tennessee decision. Service contract requiring customer to obtain service from the selling dealer unless special permission to go elsewhere was obtained was sufficient to render a car dealer a party to the service contract. So that's its third-party warranty, but you got to come back to the dealer. At least in Tennessee, they came down in 1991 and said that's a problem. Now, you contrast that with an Illinois decision that said the financing of a service contract and the purchase price of a vehicle through the same overall financing package may not by itself subject the dealer to the Act's disclaimer prohibition. So Illinois was saying you need to do something other than just simply finance both products. I don't like the may not by itself language because that means if there's another factor, you got initials on something or you have some other thing, well maybe it will pull you in. But the requiring a dealer, at least I know for a while, requiring the customer to return to the selling dealer was used as kind of a selling point for the dealer on the extended warranty because they said we'll increase your service business. You're going to get paid for this. You'll keep your techs busier. So I know it's out there because I've seen it in Florida deals. Now it gets a little confusing on service contracts as well because the federal government is precluded from regulating insurance. And under the McCarran-Ferguson Act, which is a different federal statute, all regulation of any insurance goes to the states. So if your service contract is considered insurance in your state, the federal government can't regulate it. So Magnuson Moss does not apply. Florida's weird. The provisions regarding a service contract in Florida are contained within Florida's insurance code, Chapter 634 of Florida statutes governs motor vehicle service agreements. It says that the department has to license the companies that underwrite the agreements, the companies that sell them, and it has to appoint the representatives, the dealers, as agents of that company, and you've got to have a 634 license is what it's called, but it's a license to sell that product. It also then says no other provisions of the insurance code apply. And it doesn't say specifically that they're insurance. Now, I've argued that since they're regulated by the Department of Insurance, it's clearly insurance. The Department of Insurance couldn't regulate anything that's not insurance. That was great until they changed the name of the Department of Insurance to the Department of Financial Services. So we've now lost the argument that, well, they're regulated by the insurance department, so you fall outside of this. I don't know how many other states have insurance provisions that govern service contracts, but if they do, just keep it in mind that you, if you get hit with a Magnuson Moss claim, may have a defense based on that. Overall, other warranty considerations, plain language is supposed to be used. You're not supposed to use complex terms that would confuse people, hence the sample that the FTC puts on their website, the one about the hearing aid. I mean, that was easy to read, easy to understand. It's not complex. It's one page. That's the kind of thing that they want. That's the kind of thing that they like for warranties. Make sure all relevant conditions are spelled out. If you've got anything the customer's got to do, if there's any deductible, if there's any other limitations, just make sure that's all in the warranty. If you're advertising your warranty, the FTC has a guide on what you can and can't do. It's on the website as well with the sample limited warranty. It simply says if it mentions the warranty or guarantee that's offered on an advertised product, the advertisement should disclose with clarity and prominence that the written warranty can be obtained from the dealer, essentially. So you're supposed to tell them that if they come by, they get additional terms related to the warranty. So you've got this other thing that I hear about all the time anytime I talk about Magnuson Moss. If you undertake repairs on a vehicle, you automatically create a warranty under Magnuson Moss. That's just not true. It has to be a written agreement. There is a case where a dealer did a WEO and said, you know, we owe some repairs on the vehicle. Well, the court found that the written agreement to repair the vehicle was a warranty under Magnuson Moss, and the dealer couldn't disclaim implied warranties, so their as-is went away. So what had started as a transaction where the dealer was selling it as-is with, you know, an agreement, hey, look, you know, we know there's a problem here, we'll fix that, but that's all we're going to do. It's as-is after that, turned into an implied warranty case. Because they had a written agreement to make repairs to the vehicle, and it met that first definition of what a written warranty under Magnuson Moss is. Maybe that's where the idea has come from. And there may be state requirements that if you undertake repairs to a vehicle, you warrant the vehicle. In Florida, if you undertake repairs to a vehicle for a customer, you warrant that repair, essentially. I mean, you have to perform that repair in a reasonable, workmanlike manner, and that repair can't cause damage. But if somebody comes in to get, you know, an air conditioner hose fixed, it doesn't mean you're now warranting the suspension. But if that hose ruptured and caused some other problem, and you did something during your time that you were working on that vehicle, that can lead to liability. It's not going to be under Magnuson Moss, though. That liability is solely going to come by operation of whatever Florida's common law or statutory law or whatever state you're in, whatever their laws would be regarding liability for repair work. I always tell my clients, look, if you're going to do something like that, if you've got a situation where you're doing any accommodation for a customer, I tell my buy here, pay here dealers, look, if you're extending a customer's payment, make them sign a release. It doesn't hurt anything. Worst thing in the world you can do is have that customer come back and sue you for a Fair Debt Collection Practices Act violation or something after you just did a favor for them. What was that? No, I release you in exchange for your agreeing to defer my payment. I release you from any and all claims that existed prior to today. It's enforceable. Worst case scenario, you got something to throw out there when you get a demand letter or a plaintiff starts, you know, knocking on your door saying they want money. Well, no, I got a release. That was before this. I agreed to waive his payment. So if you're going to do repair work like that, you know, ask for a release. Say, look, I don't mind doing this repair work, but I'm going to need a release, and then you get a general release that's broad enough to exonerate you from liability for the repairs and that nothing else is promised, and they agree there's no warranty created. It's just safer that way. I had a case where the dealer promised great service, and the customer sued for breach of that promise, saying that they got bad service. And there's the WEO that says we promised great service, and they said, well, that's going to prevent summary judgment because that's a question of fact as to what great service is. Now, I agree that he had some problems, but you just see ridiculous claims like that can be avoided. Don't be cute with the WEO. We owe satisfaction. Well, I'm dissatisfied. I'm going to sue you for that. That's it as far as the warranty stuff goes. I don't know if there's any questions or anything.